Hi, my name is Carrie Rinker. For those of you that don't know me, I am a food and agriculture lawyer that's based here in New York City. Today I'm going to be lecturing on counseling the local food movement, part one of a two-part series here at Lawline. I actually grew up on a farm in central Illinois, baling hay and showing cattle through 4-H and FFA, and I have an associate's and bachelor's degree in animal science, and I went on to go to graduate school at the University of Illinois in beef cattle nutrition. Interesting background for an attorney here in New York City. And in way of background, what got me here to this part of the country is I went to law school at Pace, and I have certificates in environmental and international law. After law school, I was an associate at Bud Fallon Law Offices in Cheyenne, Wyoming, which is the windiest place in the country. And I focused my practice on environmental law, property law, land use, and federal lands litigation. I worked with cowboys out west, and there I am in the picture at a cattle branding in Casper, Wyoming. Afterwards, I went ahead and I moved back to New York City to hang my own shingle, practicing food and agriculture law. I'm currently the chairperson of the American Bar Association General Practice Solo and Small Firm Division's Agriculture Law Committee. For those of you that are watching the presentation today, I would love for you to get involved in the Agriculture Law Committee with the ABA, as we're trying to build a community of solo and small firm lawyers who are practicing in food and agriculture law. In way of background, my food and agriculture client base focuses mostly on farmers and ranchers, but also small to mid-sized agribusinesses, and most recently startup food entrepreneurs, particularly here in New York City. Today I'm going to be talking about a myriad of legal issues affecting the local food movement. Primarily direct farm marketing. What is it? What are the current trends? Then I'm going to move on to cottage food operation law. For those of you that is a new term, cottage food operation law just means home-based food processing. Then I'll move on to liability and liability insurance, and then conclude with the Food Safety Modernization Act exemptions. All right, direct farm marketing. This is certainly a big topic in the local food movement. And what is it? Direct farm marketing is basically where a farmer, an agriculture producer, sells his or her product direct to the consumer. It's direct farm marketing, instead of a wholesaler or retailer, which is done in the traditional sense. So examples of this are farmers markets. For those of you that are here around New York City, we have a prolific farmers market scene in all different parts of Manhattan and outer boroughs, roadside stands, on-farm stands, and increasingly community-supported agriculture. And we'll talk a little bit more about this later, but just to summarize, a CSA has subscribers for fruit CSA, a vegetable CSA, or more recently, dairy, meat, and egg CSAs, or I have a friend in Philadelphia who is a part of a pie CSA, and they get these products on a weekly or bi-weekly basis direct from the farmer, and perhaps they go and pick them up at a certain time. I'm in a CSA on the Upper West Side. Just last night I was picking up my fruits and vegetables from a church. I was a pickup place on the Upper West Side. So what are some advantages in direct farm marketing? Well, it makes sense that if a farmer is selling the product direct to the consumer, then they're cutting out the middleman, and the middleman typically gets paid. And when you cut out the middleman, this gives a greater portion of the revenue for the farmer themselves. It also offers consumers a way to buy fresh local farm products directly from the producer, helps the consumers know where they're buying their food, which is important to a lot of consumers, and it helps facilitate consumer education about food production. I'm actually teaching a class this semester at NYU, and it's an undergraduate food law class, and I've had my students go and talk to farmers. They've actually had to conduct a series of interviews to farmers. And the reason why I'm able to do that is because farmers markets are right there and so handy to NYU campus. And they've really enjoyed building the relationship and getting to know some of the farmers, and some of them have even gone so far as to have farm tours. So this is what direct farm marketing offers for both the consumer but also for the farmer. One of the publications that should be in your materials today is a government publication that was published in 2011 by the USDA Economic Research Service. I'm just going to term it the ERS as an abbreviation. The study was based on a 2008 Agriculture Research Management Survey. In this study, they defined local food as basically direct-to-consumer or intermediary marketed channels. That would be farm to restaurant or farm to school or even farm to grocery store. However, please note that there is no per se definition of what exactly is local food. Last year I was at a grocery store and there was a sticker on the mozzarella cheese that said local. And I went up to somebody at the grocery store and I said, what does this mean? Does this mean that the cheese was made within 60 miles of New York City? Does it mean that it was made in New York State? What does this mean that you have the sticker that says local? And as it turned out, that the local for that particular grocery store chain meant within the same watershed. Okay, so there are no government regulations on what is and what is not local, but for this publication, what they define as being local is the direct farm marketing or the use of an intermediated marketing channel. Historically, as the publication delves into, between 1978 and 2011, only 5.5% of farm-sold food was sold direct to the consumer. This was only 0.3% of total farm sales. The peak within this time period happened in 1982 due to the 1976 Farmer to Consumer Direct Marketing Act. There, looks like 6 years later, the technical assistance was provided to the farmers via agriculture extension. And for those of you that are not familiar with cooperative extension, every state has a land-grant university that facilitates agriculture education at both the undergraduate level and also at the extension level for farmers. And in New York, that's Cornell University Cooperative Extension. Between 1992 and 2007, the number of farmers selling direct to consumer increased by 58%. This is a huge increase, which totaled $1.2 billion, a 77% increase in total sales. As I mentioned before, the four main types of direct-to-consumer outlets include farmers markets, roadside stands, on-farm stands, and community-supported agriculture. In the 2008 study, there were about 71,000 farms that had these direct-to-consumer outlets. 81% of them were considered small farms, which grossed about $50,000 or less on an annual basis, and only 5% of large farms, by the publication's definition, that was $250,000 or more in an annual basis, participated in direct-to-consumer marketing. On the intermediate level, the three basic types of outlets include farm to restaurant, farm to grocery store, and even farm to institution, such as a school or a government agency. In the 2008 study, about 13,000 farms participated in these methods, which had about $2.7 billion in sales. Let's compare back to the previous slide, where the direct-to-consumer was only about $877 million. So in terms of sales, the direct-to-restaurant, grocery store, or institution is about threefold of the direct-to-consumer in terms of gross sales. The publication had a very interesting table, and I encourage you to look at this in more detail after today's presentation. But essentially, About 86,000 farms, or a little bit more than that actually, 86,700 farms with less than $50,000 in gross sales had these local food sales, okay? They were number one, and only about 5,300 of the large farms participated in these direct marketing methods. 72% of the small farms did the direct-to-consumer only, so they didn't do any wholesale or retail at all. Whereas a reduced percentage, only 31% of the large farms only use the direct-to-consumer methods. As far as the intermediate channels, and as a reminder, that's direct to restaurant, direct to grocery store, direct to institution like government or school, only about 11% of the small farms use these methods, where 37% of the larger farms in this study use those methods. And you can look down at the last line for the sales, and as you can see that the small farms on average only made about $97 through direct-to-consumer marketing methods, whereas the larger farms generated about $350,000 on an annual basis. What does this mean? Small farms are more likely to market direct to consumer because it is more difficult to generate enough volume for its distributors and institutions that demand higher volumes of food. Intermediate outlets require less labor, okay? I mean, think about the farmer's market. The farmer has to go there and man the table all day for the farmer's market. They have to go and get subscribers for the community-supported agriculture. So it's more labor intensive to use the direct-to-consumer methods. Roadside stands and farmers markets accounted, though, for about 80% of the direct-to-consumer outlets, and on average, this is an interesting statistic, farmers traveled about 30 miles to farmers markets. Consumers acquaint the public face of the local food movement with farmers using direct-to-consumer outlets. That said, 60% of local food actually passes through intermediate channels, farm to restaurant, farm to grocery store, farm to school. In Table 2 in the ERS publication, also has some interesting statistics regarding marketing channels. The small farms, about 34% of the small farms use roadside stands. Again, around that same number, just a tick more, used farmers markets. With on-farm stores, the number one category was actually the medium-sized farms, farms that gross between $50,000 and $250,000 a year. And with community-supported agriculture, the number one block of farm size would again be the medium-sized farms. And this is important too, because as a food and agriculture lawyer, you need to know if you're going to practice in this area on who your clients are going to be. As far as direct farm marketing goes, what are the commodities that are being produced? It's primarily going to be fruits and vegetables. This is what you're going to see the most common. And nuts, I don't really see very many nut shares, but there are certainly a lot of nuts that are sold at farmers markets. And increasingly, we're getting into meat and dairy and egg products as well. With vegetable, fruit, and nut farms, and I thought that this was an interesting part of the ERS publication, but they tend to operate fewer acres while generating higher gross sales per acre than a field crop or livestock farm. The average for a vegetable, fruit, and nut farm is, the farm size is about 149 acres, yielding about $590 per acre. In comparison, the average U.S. farm is 349 acres, yielding about $304 per acre. So they're smaller and more profitable. But of course, these statistics are going to vary depending on where they are in the country. Are they east of the Mississippi River? Are they west of the Mississippi River? What is the soil type? What is the weather? What are the types of crops that can be grown in that area? So there's a lot of variables that take place. But overall, fruit and vegetable and nut farms are more profitable on a per acre basis, and they tend to be smaller. Table 3 in the ERS publication compared farms with local food sales versus farms with non-local food sales. And remember, the definition of local food sales means direct marketing methods. And the ages of the primary operator were about the same. Farms that were not using direct marketing methods were slightly older, but it was not statistically significant. Overall, farms that have direct farm marketing methods tend to be younger. They tend to have more beginning farmers with less than 10 years of experience, but this was not statistically significant. The next three categories, however, were statistically significant with a p-value of less than 10%. The farms without local food actually had more years of experience, slightly. However, farms that were using local food methods had more years of education. And finally, I thought this was the most interesting category, that farms that were using direct marketing methods tended to use more use of the internet versus farms that did not. So for those of you that are agriculture attorneys that are listening to this, these farms tend to be online. I have a food and agriculture law blog, and I would encourage those people that are listening here today to think about trying to reach their clientele on an online basis. Farms with direct farm marketing methods usually consider farming as their primary occupation. And in terms of the full-time equivalent, which the USDA defined as 2,000 hours of labor on an annual basis, farms that use direct farm marketing methods tend to be more time-consuming. So it's a 1.3 full-time equivalent operator jobs per farm, whereas farms that did not use direct farm marketing methods only had about a 0.9. So it's very labor intensive to use direct farm marketing methods. With the last row I wanted to mention, the average off-farm labor income. Farms that use direct farm marketing methods, because it's time consuming, right? They're less able to get a job off the farm to help supplement their income. And that's what the last line of the table is referring to. Right, so what does this mean? Local food operators are 30% more likely to list his or her primary occupation as farming. Household members devote more time to farming, 40% more operator work due to farming, which equals that 1.3 full-time equivalent. And they earn less money, and this is because they don't have as much time to work an off-farm job. Right, so where are these farms that are selling direct to consumer? They're the most prevalent in the Northeast. We're sort of in a hotbed here in and around New York City. The West Coast as well, and specifically around selected metropolitan areas. There's certainly the neighborhood effect with the local food movement. When people see their peers enjoying buying the produce at farmers market or participating in a community-supported agriculture share, they want to as well. And it's more popular in regions that produce fruits and vegetables. The West Coast, for example, produces 56% of the U.S. vegetables, fruits, nuts, and specialty crops. There's also a concentration of young farmers in the West Coast as well. Farming is the new black. It is becoming cool to be a farmer, and a lot of those farmers are on the West Coast and here in the Northeast. As far as the location of the local food sales, Not surprisingly, it's going to be the highest in urban areas. This is where the people are, this is where the money are, and about 50% of local food sales are in metropolitan counties, like New York County. And 30% of local food sales are adjacent to metropolitan counties, like Long Island, like Westchester, like parts of New Jersey. And this is larger local food farms are more likely to be located in remote rural areas. I just wanted to note that briefly. The marketing of local foods grossed $4.8 billion in 2008. I think that this has certainly grown. I haven't seen the most recent statistics. We just had another U.S. Census of Agriculture here in 2013. So I'm very excited to see what the results are from that survey on how that has affected the local food movement. Small farms with $50,000 or less in annual sales accounted for 81% of local food sales. So for those of you that are attorneys, either here in this room or watching online, and are wanting to market your energy towards this potential client base, you need to realize that the vast majority of these farms are small farms. They're not grossing more than, in terms of sales, not even in terms of profit, in sales of $50,000 a year or less. And large farms represented only about 5% of all local food sales. Now, I think that statistic is going to change as we now have the growth of the local food movement. All right, so what is the law? I know that I just gave a 20-minute background here on the trends with direct farm marketing, but what is the law that sort of affects this movement? I'm going to talk about a couple key areas, primarily contract law, what can be sold in New York via direct farm marketing, sanitation requirements, community-supported agriculture, and finally, farmers markets. All right, so people involved in the food and agriculture industry it's a very trusting culture, generally speaking. It's a handshake culture. People are generally doing business with people that they know and trust, and they typically don't put their contracts in writing, which makes it challenging as an agricultural lawyer to try to convince them that simply because you trust the person that you're doing business with does not mean that things outside of both of your controls could go wrong. I just also wanted to note that the Article 2 of the Uniform Commercial Code certainly applies to the sale of goods, and that includes food. So I think food lawyers need to help their clients get these contracts in writing. From a practical standpoint, I think the contracts should be simple and straightforward. What can be sold via direct marketing methods with farms? This is a state-specific issue. I'm going to be lecturing today primarily on New York law, but I encourage you, for those of you that are listening online in other states, to look at the law in your area on this. Don't just assume that the farmer is able to sell a certain product direct to consumer. In New York, farms are permitted to sell the following products. So long as they're not considered a retail food store. For those of you who are wondering what the exact statutory definition of that is, it's found in Article 17 of the New York Agriculture and Markets Law. So they can sell these following products: unprocessed fruits and vegetables, and I'm going to use the word processed a lot here today. Processed means you do something to it to change it. If you take carrots and you cut it up, it's processing. Eggs, so long as they're kept clean and refrigerated at 45 degrees Fahrenheit. Grains, legumes, honey, and maple syrup. There's a lot of maple syrup produced here in the great state of New York. There are also some other food products that can be sold direct to consumers that are considered highly perishable. New York allows them so long as they are processed at an approved food processing facility. They are prepackaged and properly labeled and kept at required cold temperatures to prevent spoilage and contamination. Examples would be meats, cheeses, and other sorts of dairy products. And we're going to talk about cottage food operation law in the next section. But in terms of what is an approved food processing facility, they might very well fall into that definition to allow the home-based food processing. So what cannot be sold via direct farm marketing here in New York? Home canned or jarred fruits and vegetables, pickled products, sauces, relishes, and other low-acid foods. However, they can if they are under an approved processing method at an inspected facility. Cream, custard, pumpkin meat, and other single crust pies, or cream or cheese-filled baked goods. Again, unless prepared at an approved inspected baking facility, packaged and properly refrigerated. Finally, what cannot be sold: any other food that's prepared or made with highly perishable ingredients for immediate consumption or reheating, unless manufactured and under proper food processing and vending licenses. From a practical standpoint, the New York State Department of Agriculture, I'm going to go ahead and use this abbreviation on the slide as NYSDAM, it's the New York State Department of Agriculture and Markets. They don't typically inspect these farms unless there is a consumer complaint with food safety. However, they can go ahead and inspect them at any time. If the farmer is selling, though, more highly perishable products such as meat and dairy, then NYSDAM will inspect those farms more often to make sure that everything is kept in adequate conditions in terms of food safety. There's that word processing again. Road stands, on-farm outlets, and farmers markets may not use packaging, cutting, slicing, or portioning of fruits and vegetables, meat, dairy products, or ready-to-eat food unless they follow these proper sanitary conditions that are met for retail food stores under this particular publication published with NYSDAM. So for those of you that are wanting to know exactly what those sanitary conditions are, I suggest that you look up Circular 962. All right, farmers markets. I hope that everyone here in the room and listening online has been to a farmers market before. For those of you that don't know what a farmers market is, Professor Neil Hamilton at Drake University School of Law has a nice little definition that I'm going to go ahead and read. It's basically farmers themselves, hopefully, selling produce and food that they raise or create to individual consumers at a temporary location, which is oftentimes on public property, such as a street or a parking lot, on a periodic basis, typically once or twice a week. Some of the green markets in New York City can be up to five days a week for a set period of time. About 3 to 4 hours would be a typical time span during the local growing season. There are some winter farmers markets, but overall, this is typically going to be during the local growing season. And finally, farmers markets are normally operated by a government or a not-for-profit organization. There are some farmers markets that are private run, but it's pretty rare. All right, farmers markets have what are called market rules. The farmers market comes up with their market rules that they want to have for all of their vendors. And I'm going to use the word vendor today to describe the farmer, okay? So we've got the farmer's market and the vendor. So the market rules is basically the contract between the farmer and the farmer's market. So what does this talk about? It talks about all the key terms for the farmer's market. The application process to become a member or a vendor in the market. What is the rent? What are the fees? How are the vendors approved? Are carrying crafts, like maybe homemade crafts, allowed to be sold at the farmer's market? Can the farmer's market sell products that are raised by other farms? Like there's a peach farm out in Long Island that a lot of farmers like to buy their peaches and sell them at roadside stands. Can they do that at a farmer's market as well? What are the categories of products that are allowed? Are there any issues dealing with the transfer or change in ownership in the farm itself? Will they still be allowed to be a vendor in the farmer's market? There are all sorts of issues here, and I'm going to try to keep it brief. Suggest looking at this list in your own time, but what is the enforcement process? What are the special food sanitation and safety requirements? What is the length of the market? It's typically about 5 to 6 months for those of you that are not familiar. It could be longer, it could be shorter. What is the length? Where is the farmer's market? Do they get to choose in between various locations? What is the market's operational procedures? What is its organizational structure? What permits does the vendor need to get? What documentation does it need to provide for the farmer's market? For example, we're going to talk about on-farm poultry slaughter in next month's lecture, but if they need an Article 5A license, do they have to provide the farmer's market a copy of that license? These are the types of things that the market rules goes into. Does the farmer need to provide proof of insurance? Does the food or processed food, can the processed food be sold to consumers? Some farmers markets don't allow processed food, only raw products, okay? So the carrot, before you cut it up, is considered a raw product. Can the farmer use the logo of the sponsor on their website and any advertising materials? And the list goes on and on. But this is something that food and agricultural lawyers can do for their clients, is look at the market rules and help them ascertain whether or not the terms are fair, and most importantly, at least in my eyes, just to make sure that my client understands what the rules entail. Here are some questions that I suggest that farmer vendors consider before they join a farmer's market. Who is the sponsor of the farmer's market? How long has the farmer's market been established? What is the expected crowd for the farmer's market in terms of quality and geographic reach? I was just in the Berkshires last summer, and I went to a farmer's market with some friends that was there. It was a very, very small crowd. I was really surprised. I think that it's important as a food and agricultural lawyers that we know that not all farmers markets are successful. What is the application fee and what are the procedures there? Do vendors pay seasonally, monthly, or weekly fees? Or alternatively, do they just pay a percentage of their gross sales? Who owns and rents the land upon which the farmer's market is located? Who is responsible if a consumer slips and falls right in front of a vendor's tent there at the farmer's market? Who's responsible for that? Does the farmer's market have insurance for that type of an accident? Which areas of the farmer's market get the most traffic? Can the farmer vendor choose? Who has the authority to decide which farm sets up in which location? Is there an additional fee for the preference? Is the market a producer only, or can they sell products produced from other farms? Going back to that example of that peach farm out in Long Island, does the peach farm itself need to be the vendor, or can they sell to one of my friends to go set up a little table at the farmer's market to sell their peaches? Can vendors provide free samples to consumers? Some farmers markets allow this and others don't. What is the penalty, if any, for violating a market rule? Perhaps they're suspended from the farmer's market for a week. I don't know. What do the market rules say? What is the penalty, if any, for missing a market day? Is it 3 strikes, you're out? What do the market rules say? If a vendor is forced to leave the market or is unable to continue to participate, is any portion of the rent refundable? What are the dispute resolution procedures, if any? In other words, what are the procedures going to be if there's an alleged violation of the market rules by the vendor or by the farmer? Some more questions here. Try to get through these. Does the market have all the necessary local business permits and license? Not the farmer, but does the actual farmer's market have all the necessary local business and permits? Can the vendor ask for copies of these permits and licenses? Can they get a copy to make sure that they're above the board as well? Is the farmer's market approved for WIC? And that's one of the federal nutrition programs. That's like the Women's and Children program, the Farmers Market Nutrition Program. So a lot of farmers markets are participating in this program. Does that one that your client wants to participate, are they participant in the WIC? What food products may be sold? Do they allow more perishable items to be sold, such as meat, poultry, eggs, and homemade food products? Does the farmer's market carry its own insurance in case of accidents? And we talked about that briefly with the slip and fall illustration. And what type of insurance does the farmer's market expect the farmer vendor to have? What I typically have seen is that the farmer's market will require about $1 million face value of commercial insurance, and they'll need to provide proof of that insurance in order to be an approved vendor at the market. All right, some more questions. Are there any special food labeling requirements? And this is rare. I haven't seen this a whole lot, but sometimes certain farmers markets will require products, especially home-based food processing products, to say homemade or farm-raised. Sometimes you'll see farmers markets require that the vendor have the logo of the farmers market on the label, but those are more rare. How quickly can farmers get electronic benefit transfer payments? What does the farmers market do to help promote both the farmers and its vendors? With Green Market here in New York City, Grow NYC has a list of all the farmers who participate in the market and also a link to all of their farms, which is really handy. Not all farmers markets do that. Do the market rules require the farmer to actually attend the market themselves, or can they send employees and independent contractors to do the selling? Going back to the class that I'm teaching at NYU, I sent the kids out to various farmers markets around New York City to go interview a farmer. And I think a lot of them had no idea that it wasn't the farmer themselves sometimes that were manning the tables. So it's something to think about, whether or not the farmer's market requires the farmer to be there, or whether they can hire somebody else to actually man the table. Does the farmer's market require the vendor to submit a plan before the market season, which lists what produce will be sold and the approximate volume? Does the farmer need to know that information from the get-go? Can market officials visit the farm itself to inspect the operation and its records? For example, if a farmer's market says you have to be the producer of the peaches themselves before they're sold at the farmer's market, is somebody from the farmer's market going to go out and actually verify that that's the case? Finally, I'm going to talk very briefly about community-supported agriculture. Again, I'm going to go back to the example that I'm in a CSA on the Upper West Side. I'm in the Central Park West CSA, and I have a half share. I don't have a full share, but I have a half share of both fruits and a half share of vegetables. I think I have about a 26-week period of time for my shares. I have to pick up my produce on a weekly basis on Wednesdays between 4 p.m. and 7 p.m. every week. And if I am not able to pick up my produce, then I need to send a friend. And a few times I've been busy and I've just had my share mate, the person that I'm sharing with, to go ahead and pick up my share. And there, I think in my CSA, there's one farm that's producing both the fruits and the vegetables, but with some CSAs, there's a group of farms that are producing these shares. I have a friend in Washington, D.C. who's in a CSA, and instead of going to go pick up her produce every week, she has it delivered. She also pays more per share than what I do. And we're not really going to talk about the volunteer labor requirements with CSAs. I will, however, talk about that next month. But some CSAs require their members to volunteer on the farm for a certain number of hours, either on a monthly basis or throughout the growing season. In the CSA that I'm in on the Upper West Side, I'm required to volunteer a shift at the CSA pickup. So you'll also see requirements with volunteer, which leads me to my next slide. A lot of farms are not using CSA agreements, but I think that they should be used more often. For those of you that are attorneys that are listening to this, I would encourage your clients to consider putting together a CSA agreement. Now, from a cultural standpoint, I think that we should keep these very simple, but it should address some of the following issues. How long is the growing season? How long is a CSA going to last? Do they have to go pick up the food on a weekly basis like how I do? Or is it going to be delivered like my friend in Washington, D.C.? What types of shares are available, and what types of produce should the consumer expect for that share? How is a share defined? And I get this question a lot. I don't know the answer, but the answer needs to somewhere be in the CSA agreement. Typically, shares fluctuate on how much is given to the consumer depending on the harvest that year, because the whole purpose of community-supported agriculture is that you want the consumer to help bear the risk along with the farmer. If it's a great year, it's a great harvest, the consumer should also have a great year and get a good chunk of that harvest as well. But if the conditions are bad, then the consumer might have smaller amounts of produce that are given. From a business standpoint, CSAs are great for farms because they're able to get paid up front for their harvest and to secure those sales. The CSA agreement should also talk about what will happen to forfeited products. So if I don't go pick up my products on a Wednesday night to get my product, what usually happens? Well, you usually forfeit the products, and most CSAs donate food to a certain organization. And of course, if there are any volunteer requirements on behalf of the subscriber, then to go ahead and enumerate there in the CSA agreements. Be cautious about using the word partner. I don't like using the word partner in CSA agreements. Those of you that are attorneys here in the room and listening online, you know that partnerships are a very specific legal business organization, and I don't want to infer that the consumer and the farmer are sharing in any kind of profits, or they're not forming a general partnership. I don't love the word shareholder for that reason either. I prefer the word subscriber in their relationship. The consumer is a subscriber to the produce. All right, cottage food operation law. So a couple years ago, I first heard this term and I was thinking, what? Are we making cottage cheese? I was really confused. But cottage food operation law is basically talking about home-based food processing. So somebody who's in Brooklyn making pickles in their kitchen and wanting to sell them direct to consumer. That's cottage food operation law. So that's what we're talking about here today. All right, so it's important to understand the interaction between whatever state you are in, the commercial kitchen license. Here in New York, it's Article 20C, and the cottage food operation law. The statute in your state, and in even New York, we don't call it cottage food operation law. If you Google or if you go through the statutes in the New York agricultural markets, you're never going to see the word cottage food operation. They're going to call it home-based food kitchen, or something like that, something to that effect. But here in New York, we apply an exemption approach. So by default, everyone who's processing food needs to have a commercial kitchen license, which is in New York, and an Article 20C license. But then we have these exemptions for cottage food operators who are allowed to go ahead and make and process this food out of their kitchen and then sell it direct to consumer. So in New York, we apply an exemption approach. And this is given from the states that regulate food establishments. Here in New York, the law dealing with food processing establishments is found in the New York Agricultural Markets Law in 251-Z-2. And as you can see here in this whole big long list of exemptions, the very last one down there is home-based processed food, so long as certain conditions are satisfied. And that's what we're talking about here today. What are those conditions that need to be satisfied to be a valid cottage food operator? If you don't fit into this cottage food exemption, then your client needs to apply for an Article 20C license. Okay? They need to have proof that they are of good character, they have adequate experience for a commercial kitchen, and they're going to maintain the cleanliness of the product so it's not adulterated. There's a small fee that needs to be paid on a biannual basis of $400, and the license period varies according to the applicant's last name. So if these conditions are not satisfied, NYSDAM, or the New York State Department of Agriculture, whatever your State Department of Agriculture is in your state, likely can also decline or revoke this license. And if you are a holder of an Article 20C license, there are certain requirements that need to be kept, such as record keeping. NYSDAM can come and inspect the facility. There are certain educational requirements that need to be satisfied. All right, so let's get back into cottage food operation law. And I'm going to talk, I have a slide at the very end of my presentation about my book, but I have an entire chapter of my book on cottage food operation law. And I'm also going to be talking about, I provided in the materials, a Harvard Food Law and Policy Clinic paper called Cottage Food Laws in the United States. This was very recently published last August, and I think that the publication did an outstanding job just giving a survey of cottage food operation law throughout the country. So with the local food movement, we have had a real growth in small-scale food production and home-based food processing. And this includes primarily non-potentially hazardous foods that are made in the kitchen. Most states around the country have cottage food operation law now. But this is a real growing area, and a lot of states that do have cottage food operation law, we've seen them pop up here in the last 5 years, 3 years, 2 years. And I imagine that the states that do not have cottage food operation law will soon enact some. There are advantages in cottage food operations. It provides community residents with locally produced food. It encourages food production. Creates cost-effective outlets to create value-added products from the excess of fruits and vegetables. So in other words, if a farmer has a CSA or they're selling at farmers markets, and there are a lot of strawberries that they don't know what to do with. Like, what are we going to do with all these strawberries? Well, they could make jam and then sell the jam at the farmers market. And then it's also more money to stay in the local economy. So here are all the states that allow cottage food operation, and it might be easier to look at the states that don't, but I'm here in New York, and the neighboring states, New Jersey and Connecticut, do not allow for cottage food operations. So here's a very short list of states that don't allow for cottage food operations, but you can see here that the vast majority of the states do allow for them. So although about 2/3 of the states have cottage food operation law, there's very little uniformity among the laws around the country. It's very different when you compare Illinois versus New York versus California versus Texas versus Delaware. The states are really different upon this. I'm going to be talking about some trends on a national level and then sinking back into what's happening here in New York. But for those of you that are here in the room and listening online that are not practicing law in New York, I encourage you to really pay attention to the nuances in your particular state. There's a lot of differences. Here are a couple key things that you'll see here, like in Rhode Island, for example. It requires that the products be produced in the kitchen that is on a premises of a farm. So somebody who is just wanting to make jam and jelly out of their kitchen, if they're not a farmer, they don't live on a farm in Rhode Island, they can't sell a cottage food operation good. Some states, however, have a cap in allowable sales at a very low amount, restricting the cottage food operator for it just to be a hobby and for not to be a launching pad for a traditional food business. I don't really like this kind of a trend. I think that we need to encourage people to have viable businesses, viable food businesses. New York does not have this type of a law. Another difference you'll see from state to state, in some states, the cottage food law is relatively easy to find with very clear requirements, while in other states, cottage food laws are very hidden with no clear directions. If you're interested in cottage food law in New York, you can go on the New York Department of Agriculture's website, and there's like a whole webpage just based on cottage food operation law. It's pretty easy to find. In other states, it's not so lucky. So how are cottage food operation laws passed? Usually it starts with legislation, and then the statute directs the government agency to enact regulations. However, in some states establish cottage food rules through regulations only. Sometimes, the State Department of Agriculture just implements it and posts it on the website. And I think that this is what happened here in New York. I don't believe that there was any kind of legislation regarding cottage food operation law. So let's back up. The FDA, the Food and Drug Administration at the federal level, they established a model food code long ago that could have been adopted by the states. For the states that adopted this model food code, they didn't have any provisions dealing with home-based food processing. In fact, the model food code didn't allow for any processing to take place outside of commercial kitchens. So the states that did adopt this model food code from the FDA, they have had to, therefore, legislatively enact an exemption. And for the sake of time, I'm going to go ahead and move forward to the next slide. There are 5 typical restrictions that are found around the country with cottage food operations. One of which is the types of cottage food products that are allowed, the limits on where the cottage food products can be sold, whether or not they require registration, licenses, and/or permits. The 4th is any limits on total sales. And the 5th are food labeling requirements. So all the laws and restrictions in this area tend to fall in these 5 categories, and I will note the law in New York with these. So the types of food products allowed. Typically, this is restricted to foods that are not potentially hazardous. Some states just say that you can sell any good that's not potentially hazardous, but they don't really go and define what that includes. Most states, however, enumerate what these foods include. Here's an example statute from Arkansas. As you can see here, they list bakery products, candy, fruit butter, jams, jellies, and similar products. California has a big old list, and I don't even know if you can even read this on your screen. Hopefully you can, or look in your notes. But California has the longest list of enumerated allowed goods that I have seen around the country. On the other hand, some states have more specific allowances or restrictions. Take, for example, Wisconsin's quote-unquote pickle bill. It only allows for processed fruits and vegetables that meet a certain pH value. So it's gone so far as to talk about pH value, such as pickled fruits and vegetables, sauerkraut, salsas, chutneys, jams, jellies, and applesauce. This is kind of making me hungry for some Indian food. All right, Vermont, on the other hand, only allows for baked goods like breads, cakes, pies, or other food products made from flour. So Vermont really sticks to flour goods. Let's go back to the FDA code. So this is all kind of rooted from the FDA model code, and it has a very detailed and technical definition referring to the acidity in the food. It focuses on the pathogenic organism growth of toxic formation, which is over my pay grade. But the FDA code basically tried to identify the foods that are more susceptible to food pathogen growth. So examples of this would be meat, dairy products, shellfish, mushrooms, low sugar jams and jellies, cooked vegetables, low acidity pickles and salsa, cut melons, cut tomatoes, untreated garlic in oil mixtures, baked goods subject to spoilage such as cream-filled pastries and raw seed sprouts. Here in New York allows for home processed food and includes any food processed in private home or residence using only ordinary kitchen facilities. So I have here a picture of two people here making dinner in a kitchen, and I know that they're making chicken, and chicken is not allowed to be sold in this baked form here to consumers, but you can see they're just using ordinary kitchen utensils. This is what we're talking about here in New York. You can't go and have special equipment that you are using in your basement that is not a cottage food operation here in New York. And it excludes the use of potentially hazardous foods, including but not limited to pickles and relishes prepared with low acid fruits and vegetables, poultry, meat products, fish, and seafood. So no commercial kitchen can be used, and it needs to be in the private home or residence. It can't be in the garage. It's restricted to the following products in New York. Bakery products such as bread, rolls, cookies, cakes, brownies, etc. Traditional jams and jellies, repacking and blending of dried spices and herbs, and snack items are allowed, like popcorn, caramel corn, and peanut brittle. That's supposed to be a picture of peanut brittle there in the corner, and candy, but not chocolate. Chocolate is not allowed. If the product requires refrigeration, then it is not allowed to be produced under the home processor exemption. New York views food products that may require refrigeration as being potentially hazardous. Examples of these include fruit and vegetable breads, that lovely cheesecake that's there in that picture, pickled or fermented foods, meat, fish, or poultry products, vegetable oils, garlic, wine jellies, etc. There are 3 general types of cottage food products that are allowed. These are how the statutes around the country and the cottage food law usually fits into one of 3 categories. Number 1, a broad list of allowed foods. We saw that in California, right? Broad list. A limited list. Oh, sorry, the broad list would be where it's very, very generic, where it typically will just say non-potentially hazardous foods, and it may or may not enumerate a big long list like what California did. The second category would be a limited list of allowed food. And then the third category would be other or more restrictive states. Examples would be no hand home canned goods made using a pressure cooker. Primary ingredients must be grown by a microprocessor or pickled products only. So here are the states and where they fit in. And you can see that New York is under the big long list of a broad list of allowed goods. So that's where we fit into this whole scheme of things. All right, the next common area is that cottage food law can talk about are limits on where cottage food products can be sold. Most states restrict the sale to be direct to consumer. And New York is silent on this, but most states say if you're going to have a cottage food good, if you're going to make jam and jelly out of your kitchen, you got to sell it direct to consumer. They don't permit sales to restaurants or other retail food establishments. It's restricted to sales at farmers markets, county fairs, roadside stands, on-farm stands, at the farmers' premises, or even community-supported agriculture. I haven't seen any pickle shares or jam shares, but I guess they could most certainly exist. All right, so what's happening in Tennessee? A Tennessee statute says that the cottage food goods may be sold at the person's personal residence, a community or social event, including a church bazaar or festivals, flea markets or farmers markets. So some of these regulations are very narrow on where they could be sold. In California has 2 levels of cottage food where they can be sold. Class A, direct to consumer only. Class B is they can also sell to restaurants and other retail food establishments. All right, where does New York fit in on the scheme of this? We are in category 3, where the law is silent, along with Louisiana, Massachusetts, North Carolina, and Utah. So here in New York, sell direct to consumer, sell direct to restaurant, it's all okay. Where the vast majority of the states, as listed in the first column, require that the products be sold direct to consumer. There are some additional common prohibitions. One is a restriction on internet sales. And New York actually has this requirement, but in my food law class that I'm teaching at NYU, I said, go talk to a cottage food operator. And a big chunk of them were able to buy home-based food off the internet. So I won't list the websites here in today's presentation, but there's a lot of internet sales going on in New York, even though it is prohibitive. I think that it's only a matter of time between that the New York State Department of Agriculture starts to pay more attention to this. So for those of you that are food lawyers, I would certainly counsel your clients to stay off of the internet. They can, though, in New York, use the internet for marketing like any other business, and that's fine. They just can't be selling their product there on the internet. So why is that? Why do we even have that prohibition? And it's because this food has to be sold in intrastate in New York and actually in every state that has a cottage food law. And why is that? Because if we pass interstate commerce, if we pass state lines, now the federal law applies, where cottage food law, if it's only sold within the state of New York, we're only talking about intrastate commerce, and in that instance, we're able to have these various exemptions from federal regulation. So that's why a lot of states restrict internet sales. Some states like Georgia, though, specifically allow for internet sales so long as they're purchased from someone at that state. And some of my students at NYU that purchased the cottage food product online, the website did say, but it must be purchased by somebody from that state. I don't know how much is enforced. Some states have required registration, licenses, and permits. And this really varies from state to state. on what is happening here. New York is, and this is where the Harvard article did make a mistake here with New York. New York does actually have a requirement for registration. It doesn't cost anything. It doesn't cost a penny to register with the New York State Department of Agriculture, but they are required and they should be filing that registration form. So here's some other examples of what's going on in other states. Alaska requires cottage food operators to obtain a business license. Seems easy enough. Colorado requires a certificate in safe food handling and processing. Washington requires a food and beverage service workers permit. Utah requires a food handler's permit. Pennsylvania requires inspection of home-based food kitchens. And what are we doing in New York? For those of you that are interested in practicing this area, just follow that link and you'll get to that nice, pretty registration form that needs to be filed with the New York State Department of Agriculture. It's just mostly so if there is a food safety problem, that the New York State Department of Agriculture knows where to find you. Where is this good being produced? And you also need to let NYSDAM know whether the water supply is a municipal or a private well in New York. If the home-based processor is using a private well water system, and I grew up on well water, then he or she must have a water test analysis performed for coliform and must register this information with the New York State Department of Agriculture. Even though some cottage food operations are exempt from Article 20C licenses, they are still subject to inspection from the New York State Department of Agriculture. Again, from a practical standpoint, this is really only done if there's a problem, but your clients need to be prepared that an inspection could take place at their home for their cottage food good. What are the typical fees that are associated with cottage food operations? In New York, it's free. It's oftentimes very cheap. In Maine, the filing fee is $20. In Washington, though, they have a little bit more expensive fee. They have a $125 inspection fee and a public health review fee of $75. There could also be a processing fee. So this stuff is going to change from state to state, and look up and be informed of what the filing requirements are in your state. As I mentioned a little bit ago, there are states that have limits on the total sales. Approximately 50% of the states that allow cottage food operations have some type of limitation on the gross sales on an annual basis. This limitation is typically between $5,000 and $50,000. And there are some examples listed there. Some states allow for a gradual increase in these sales caps, such as Michigan or California. In some states, like Colorado, put a limit on each eligible food item. I thought this was a peculiar regulation that they have here in Colorado. So an example would be like $5,000 for each flavor of jam. If you've got grape jam, $5,000. Strawberry jam, $5,000. So I wonder how difficult that is from an enforcement standpoint there in Colorado. A few states frame their sales restrictions based on weekly sales, such as Tennessee or Vermont. And as you can see here, the states that with limits on gross sales, New York is not on this list. There is no requirement here in New York. And here are the whole slew of states that do not have any limit on sales. You can kind of, by looking at the number of states, about half of the states that have cottage food law have a restriction. All right, we're getting ready to close our cottage food operation discussion here today. But most states that allow for cottage food law operations also have labeling requirements for these. Typical requirements include the name of address of the producer, the manufacturer, the common or usual name of the product, ingredients of the product in descending order of predominance. Any food allergens need to be on there, net weight and volume, date, and typically in a lot of states you're going to find some kind of a requirement such as made in a home kitchen that has not been inspected by the State Department of Agriculture. So that's generally what you'll find. But there are a few states though that have no food labeling requirements for cottage food. That is Louisiana, Montana, and Vermont. In New York, what do we require? The name and address, common or usual name, the common or usual name of each ingredient, the net weight. Seems simple enough, right? But when I had my students at NYU go and purchase cottage food goods, I was surprised about how many of the labels did not have these specific ingredients. So you as a food lawyer should be aware about what the law is and do a food label review for your cottage food operator just to make sure that they are in compliance with New York law. There are other legal considerations for cottage food operations. For example, it may conflict with a residential lease. Maybe the landlord doesn't want you having a business being run out of your home. Maybe the local zoning code prohibits commercial activity in the residential area. If that's the case, maybe your client needs to seek a variance or a special use permit. This is a very important point here. Insurance. Homeowners or rental insurance does not cover for commercial activity. A cottage food operation is a commercial activity taking place in a home kitchen. Therefore, you should counsel your clients to get an additional commercial insurance policy that will cover slip and falls, etc. They should also have recall insurance if there is a food safety issue. So the combination of those two insurances should cover your client. And this is what I do also as a food lawyer. I look at their business structure. Are they a sole proprietor? Should they form a limited liability company? And I don't get too LLC happy. I think some lawyers really misguide their clients in thinking that everybody has to form an LLC because I want the legal fees. And I'm not that way. I think that you should really look at things from a case-by-case basis. Are they only selling $5,000 of jams or pickles a year? Are they a bigger operation where are they more susceptible to a food safety issue? What kind of good are they really what are they selling? And then discern whether or not it's proper for them to form a limited liability company or a limited partnership or any other kind of limited business structure. And finally, as a food lawyer, I also think about protecting their intellectual property, okay? Cottage food operators typically start off making their good at home. Maybe they're making cookies from their home-based kitchen, but then they later grow into a commercial kitchen. They're going to want to protect their brand and their trademark, right? So those are things that food lawyers can do for cottage food operators. All right, with liability, there are two main types of liability, and we're going back to the first year of law school on this: premises liability and products liability. With premises liability, this really affects the local food movement a lot. Farmers markets, roadside stands, pick your own produce. You've got consumers coming to your farm to pick strawberries, that's pick your own. Agritourism, maybe you have a corn maze or a hay ride. I guess we're getting close to Halloween. On-farm sales, farm tours, cooking classes. Premises liability is an issue with all of these examples. Let's think back to the law school days and the different standards of care for trespassers, children, licensees, and invitees. Remember that? We're going to focus on invitees today. So as a reminder, landowners owe the highest duty of care to an invitee or members of the public that enter the land for the purpose of business dealings. Examples include farm stands, pick your own produce, cooking classes, on-farm horse or livestock sales, corn mazes, hay rides, petting zoos, and farm tours. I mean, a lot of farms participate in farm tours. Landowner will be subject to liability for physical harm caused by the invitees by a condition on the land if he or she fails to exercise reasonable care and he or she knew or should have known about the harmful condition. Okay? So landowners who have members of the public that come onto their property should think about using barriers to prevent the public from entering those areas that may be more dangerous. And that could also include farm equipment, okay? Especially if there are kids that could be coming onto the property. Really be careful about farm equipment. There should also be signs warning invitees of these potential hazards. Landowners with pets should be particularly mindful of potential injuries, such as dog bites. This is my dog Taylor, who's at my farm in Illinois, and I know that she would not bite anyone, but that is, landowners, farmers with dogs should be conscious of potential dog bites. Okay, so premises liability, we just talked about. Now we're going to shift to products liability. Products liability is the legal responsibility for personal injuries and property damage caused by defective products. Okay, so you make someone sick because of a food safety issue. Farms and food entrepreneurs selling food directly to consumer increase their likelihood for potential product liabilities. Thinking back to the very beginning of our presentation, about over an hour ago, what were the advantages of direct farm marketing? One of which was there's no more middleman, right? So they're able to make more money. But because of that, there's nobody else to point their finger to if there's a food safety issue. So risk management is especially important for farmers that are selling their products direct to consumers. States differ in their products liability theory that they employ with food products. New York is a strict liability state. So for example, if a consumer at a pick-your-own farm picks, berries and consumes those berries and then becomes ill, but those berries were contaminated and that person was very, very sick, a New York court will likely hold that the berry farmer will be strictly liable for the consumer's injuries. I already talked a little bit about this, but just to debrief, what I do as a food lawyer is I counsel my clients on risk management methods. One we already talked about, do they need to form a limited liability company? Number 2, insurance. Insurance should not be forgotten. And then third, food safety and sanitation. Let's move on to insurance. There's a whole slew of different kinds of insurance. And just in case a few of you are not familiar, insurance at the end of the day is basically a contract. It's typically drafted in favor of the insurance company. And not all insurance products are the same. Something that I do as a food lawyer is that I review the insurance policy with my client. Number 1, to make sure that there are not any concerns that need to be addressed should they be getting a different insurance policy. But 2, I want to make sure that they understand what the insurance policy protects them with. Pay attention when you do this insurance review to the duties of the client under the insurance policy. Again, insurance is really at the end of the day is a contract. The insurance company has a duty to indemnify the insured while they have the duty to defend the farmer in a lawsuit for a covered risk, not for anything, but for a covered risk under the insurance policy. So what is covered and what is not covered, that is between you and your client when you do that review. The farmer, on the other hand, as the insured, has a duty to pay the premium, right? They have to pay for the insurance. They have a duty to cooperate, and they also have a duty to disclose to the insurance company relevant information. The insurance company's duty to defend the farmer is carried out by hiring an attorney chosen by the company and controlling that attorney's right to settle. If the farmer or food entrepreneur is dead set against settling, the insurance company still has the right to settle anyway. Importantly, once the insurance company pays out its policy limits, it no longer has a duty to defend the farmer or food entrepreneur. Therefore, insurance is not the end-all be-all when it comes to risk management. It is only one piece in the risk management puzzle for a farmer. The purpose of an insurance policy is essentially to shift the financial risk of the food and agriculture operation to the insurance company. The insurance company will pay any covered claim up to the limit and defense costs in a lawsuit. And then they're done. Clients naturally are tempted to save money on insurance premiums, and perhaps they'll choose an insurance policy with a high deductible. And I think that we as lawyers can relate to this feeling. I know that we feel the same way sometimes with malpractice insurance, right? And it's the same thing with farmers. It's more overhead expense. But inadequate amounts of insurance won't pay the farmer or their food entrepreneur what they need to stay up and running if a loss occurs. So it's important as a food lawyer to have a conversation with your client to determine whether or not that they're properly insured, if they have enough insurance. There are two basic types of insurance: a claims made versus an occurrence-based policy. What is a claims made policy? It will only cover the insured for the claims made within the window of time the insurance policy is in effect, so long as the claim is made within the specified time. However, on the other hand, the occurrence-based policy covers anything that happens within a certain window of time and will pay out regardless of when the claim is made to the insurance company. So as a food lawyer, when you review the insurance policy with your client, educate him or her on the type of policy that they have and, frankly, what type of policy that they should have. Pay attention to the exclusions. An insurance contract almost always has exclusions that are carved out. These typically include intentional acts such as theft by employees, assaults, alcohol-related events. Other exclusions may relate more specifically to the type of insurance that is involved. For example, a typical farm owner's policy might not be adequate to insure against losses suffered from the flooding of a nearby creek. That's one example. As a food lawyer, you should also know the type of coverage. Basic coverage is intended to compensate for losses like fire, lightning, explosion, windstorm, hail, riot, or civil aircraft or vehicle vandalism, theft, the list goes on. Broad form coverage, in addition to all those basic coverages, also adds additional coverage for damage such as weight of ice, snow or sleet, falling objects, etc. And there's also additional special coverage that can be purchased. Here's the insurance puzzle for farmers. They get inundated with information on different types of insurance. They can't decide on what exactly is proper for their particular farm. I'm going to go ahead and go through some of the most basic types of farm insurance. Most farmers have a farmer's comprehensive personal liability policy. They may not really understand what it covers, but most farms do have this. I suggest that you review this policy with your client just to make sure that it is that they understand what it covers. It's also known as the farm owner's insurance. This type of policy normally only covers activities ancillary to farming. It does not cover agritourism or cottage food operations, okay? Pay special attention to the exclusion section in this policy and what is not covered. For example, sale of processed vegetables or meat products at the farmer's market or roadside stand. Injuries to the policyholder or a family member, property damage by the insured, him or her himself. These are all things that are typically excluded. I've already talked a little bit about homeowners and renters insurance, but remember and really keep this in mind that if your client is running a food business out of their home, it is not going to be covered under homeowners and renters insurance. They need a commercial policy and probably also a product recall insurance as well. So they need to be thinking about commercial insurance. This is particularly important if your client is involved with processed food products, not raw, but processed food products, or if they're doing any on-farm slaughter, definitely need some commercial insurance. They're doing agritourism. Remember, it's not included in the farm owner's insurance. They need to think about getting a commercial policy. Food entrepreneurs that are selling their products direct to consumer, they should really be thinking about getting a products liability policy. And also farms that are selling raw milk. And I think I'm going to be talking a little bit about raw milk next month, should be considering a products liability policy. I am not going to be delving into crop insurance because crop insurance is a whole lecture in and of itself. And for those of you that are interested in learning more about this, about 2 years ago, I moderated a CLE for the American Bar Association on crop insurance, a little bit on livestock insurance, but mostly on crop insurance. And it is available for purchase through the American Bar Association web store. But we have federal crop insurance that is subsidized by the U.S. Department of Agriculture Risk Management Agency. Subsidization is probably not the best word, but the federal government basically reinsures the private insurance company for crop insurance. And it is available for nearly every type of commodity ranging from sweet corn to raisins. It protects the producer against natural disasters such as drought or flood. Livestock insurance, analogously at the federal level, you can also get reinsured on livestock insurance, which is pretty similar to crop insurance. Again, this is only for natural causes only. On the flip side, livestock insurance is also offered by private insurance companies that have wider coverage, including things like theft. And equine insurance, and I know we're talking about direct farm marketing, I'm not going to get into equine insurance today, but it's a big deal. And there's a lot of different kinds of equine insurance. And again, I suggest that ABA webinar that I moderated, Julie Firstman, who is an equine lawyer in Michigan, spoke on this topic quite well in that CLE on equine insurance. Some farms should think about getting cyber insurance. This is a fairly new type of insurance, relatively speaking, and it addresses risks associated with doing business over the internet. Covered risk can include privacy issues, infringement of intellectual property, trademark or copyright infringement, stolen credit card information, like from PayPal or Google Checkout or any other online credit card processor, and even computer viruses. If your farmer or food entrepreneur is selling stuff online, I would think about getting a cyber insurance policy. Motor vehicle insurance. Food and agriculture operations should pay special attention to their auto insurance policies and vehicles. If those vehicles themselves are used to transport goods, livestock, or special equipment. A commercial automobile policy or a special rider might be needed in those situations. Farmers and food entrepreneurs should also just have a candid conversation, not only with you, but with also their insurance agent on exactly what's going on in their operation, because there are a lot of special riders or endorsements that a farm should have. For example, if they have agritourism or agritainment on their farm, a petting zoo, they're doing on-farm poultry slaughter, or transporting frozen genetics such as embryos or semen, their insurance company likely has a special rider for that particular good. I was contacted by a farmer client a few months ago who wanted to do like a show camp, like a show cattle camp on their farm. And this was exactly what I encouraged them to think about. It wasn't going to be included under their basic farm owner's insurance, but there was likely a rider that was available through their insurance company for like camps for kids. Umbrella insurance is oftentimes misunderstood. I think it's a horrible name for insurance because instead of an umbrella that covers and fills in all the holes from the rain, think of it more like a top hat, okay? It's only going to give you coverage for the things that you already have coverage for. It raises the limits. So if you have a $1 million farm owner's insurance policy and a $2 million umbrella, then it raises the limit for your farm owner's insurance policy to $2 million. I say this because as food lawyers, do not improperly counsel your client to get an umbrella insurance policy when they're doing activities that are not properly insured under commercial insurance or product recall insurance or a farm owner's insurance, etc. How much insurance does a farmer need? Depends on their budget, depends on their risk appetite, depends on how much assets the farm has and how much the farm is worth. Most operations should have at least $1 million. As a rule of thumb, they should have more insurance than the amount of assets that they have. But again, it depends on the operation. For sake of time, I will not be talking about the Food Safety Modernization Act today, but I will go ahead and fit this material into the Counseling the Local Food Movement Part 2 that I will be giving next month. And to skip over to the very end of the presentation for a few final announcements. For those of you that are interested in some more information on just building and growing a food and agricultural law practice, on the first Friday of every single month, I have what's called a Fridays with Carrie Skype presentation. And just email me at carrie@rinkerlaw.com and I'll go ahead and get you signed up for that. I just have a very casual conversation with people that are interested in being a food and agriculture lawyer, and it's via Skype. I also just wrote a book that talks about all these issues that we mentioned today and more. It is available for sale on Amazon.com for about $25. It does focus on New York law, but a lot of the chapters do also talk about just general trends and also federal law. So for those of you that are here today. And then finally, this is all my contact information. There are multiple ways that you can contact me. You can also tweet me, you can Facebook me, you can find me on LinkedIn. If you enjoyed today's presentation or if you have any other follow-up questions, feel free to send it me the question via email. I appreciate your time and good luck to you as a food lawyer.